And if you have any questions, I'm going to be doing a short question and answer session at the end of the meeting. On your Zoom application, you have a Q&A section, and I will pick these up at the end with everyone. So quick introduction then. My name's Matt Riley. I'm the Director for Transformation and Security at Complete IT, and I'm also the Data Protection Lead for Sharp UK. This webinar today is the sort of culmination of quite a lot of content we've been creating and putting out over the last month related to data protection. So, for example, a number of blogs on incident management, how to build out frameworks and how to respond, how to protect your data, what sort of things you should put in your supply agreements. And again, generally those top level concepts of data protection and data security. In addition to this, a number of fact sheets and guides, for example, that can be shared with teams on how to spot phishing emails. And finally, some quizzes to test your knowledge against what best practice might be. So I would always recommend that everyone who's on the webinar today, please follow us on some of the social media channels, because this is, as well as some specialist stuff like this, there's plenty of other content and updates from what's going on in the world. So moving on. Agenda for today. So we're going to go through a few of those top level key concepts around the general data protection regulation. We'll then go into a bit around what the individual rights are, why they're important, and really start to focus on at the end, those practical aspects related to subject access requests and right to be forgotten. So hopefully everyone can take away some real practical things from today that will aid them should they get these type of requests. Okay, so the first piece we're going to look at is three of the main concepts within GDPR, because this does give us context a bit later on. So first of all, the data subject, then the data controller and data processor. And these are legal terms. They form part of definitions within the general data protection regulation as a part of the UK law as well as European law. So I thought I'd take you through an example as well, because these are often quite complicated setups, to be fair. So data subject. We are all data subjects. A data subject is the individual whose data we're talking about. So me as a Complete IT employee, I share my data with Complete IT. Complete IT will collect this data for a defined purpose and process it accordingly. They are then the controller of that data on behalf of me, the data subject. Complete IT might also recruit third parties to do particular pieces of work on behalf of Complete IT, who can use the data that gets shared with them for a really specific purpose, which the data controller defines. So a practical example of this, I come and work for Complete IT, and I share my personal email address with Complete IT for the purposes, say, of communicating with me outside of my work email address. Now, Complete IT have a hosted HR system, and my personal data will be put into that hosted HR system that is hosted by a third provider. Now, in this instance, my data as the data subject is given to the data controller, who gives it to this third party. And the whole point here is the relationship between the three. I provide my data, Complete IT can use it for a purpose, the data processor must use it for that same purpose, or a purpose that Complete IT say they must. So this is a chain as such, and it is really important because a lot of what the concepts we're about to talk about all relate to the data controller. So the organization in the middle of this who effectively determines the purpose and means of processing for that data, although they might share it with other people. The other concept that overlaps very much so with this is data processing. So I'll take you through a good example. So I go to a trade show and I get the business card of someone who's looking for IT services. At this point, I'm collecting their data. From the moment I collect it as an employee of Complete IT, all the way through to eventually that data getting destroyed, I am processing it on their behalf, and therefore I must look after it. So again, someone passes me that business card and says, please give me a call to talk about your services, for example. So at that point, I'm using it. I'm potentially adapting it. I'm potentially sharing it with other members of the team to help them support that end person. I'm also storing it. So one of the real misconceptions around this is that just if I'm storing it, I'm not processing it. You absolutely are. Microsoft, for example, for most businesses that have Office 365 and Microsoft 365, Microsoft are a data processor, where they are doing nothing with that information except purely storing it for us. So businesses have a responsibility to look after data subjects' personal data from the minute they collect it to the minute they destroy it. So individual rights then themselves, although there were earlier versions, the GDPR, as it was released in 2016 and then implemented in 2018, created 8 individual rights. So these are enshrined in law, and where businesses are using data, processing data, they must make sure that they make the data subject aware of these rights and what they mean to them. So this webinar itself will cover off the 2 most frequently seen individual rights. Those 2 are the right of access and the right of erasure. Right of access is commonly known as many, many different things, but subject access requests, SARs, DSARs, and we do see quite a lot of these happening in the world, and we have done since sort of GDPR was implemented. More recently, we've started to see right to erasure requests. Historically and traditionally, they were obviously known as right to be forgotten requests, and mainly they were very much linked to people not wanting to appear in Google search engine results. But more recently, we've seen quite a significant change with businesses commercializing on the dealing with these sort of requests on behalf of those data subjects. So the right to erasure has increased in importance very much so even in the last few months. The other individual rights, most people won't ever really come across in the day-to-day jobs. We will touch on right to be informed, but yes, the others aren't particularly evident, although the right not to be subjected to automated decision making is something that does come up a lot in the recruitment process, where, for example, a business will use scanning tools to review CVs as they're coming in and make decisions based on those CVs. The individual has a right to say, I'd like my data processed, reviewed by a human, not a machine. So predominantly, it's not a big thing, but the other 2 are, and we'll dig into them today. So first of all, why is all of this important? Businesses have a legal responsibility to respond to an individual rights request, and there are strict timeframes around what this process looks like. So the data subjects can make a request to a data controller, and it must always be to the data controller. If you're processing data on behalf of someone else, you can't respond to those requests. And if they're not happy with the response they get, or they don't feel they get much information or enough information, or they're not happy with the timeframes that are laid out in law, and we will come to today, they have a right to complain to the Information Commissioner's Office. In those instances, the ICO will get in contact with the data controller on behalf of that data subject. And the whole point of this is they are going to challenge around every aspect of that complaint to make sure that the data controller is adhering to their legal obligations. And actually in 2019, 2020, I haven't been able to find last year's data yet, the ICO found fault in over half of cases, which is quite a phenomenal number. In that time period as well, since then, 108 fines have been given out, but the technical term is due to insufficient fulfillment of data subject rights. So it's doesn't dig into the data, doesn't dig into each individual right or what aspect of it, but generally speaking, that equated to about £18 million worth of fines in all. And the reason this is now much more important than ever for businesses is there are companies out there who have turned doing this into a business. So that's one of the things we'll touch on today. But really, one of the key points around this is requests made against these individual rights shall be provided free of charge. So if someone puts an individual right request into you as the data controller, you can't charge them for that service. Now, I say that there is a caveat. GDPR does state if you believe the request is manifestly unfounded or excessive, you can make a reasonable charge. But as the data controller, you have to be able to define manifestly unfounded or excessive, and be able to stand by it. So in case the ICO come, you have to then be able to justify it. Likewise, you can reject them if, again, they are manifestly unfounded or excessive. But again, you have to prove that. It is not for the data subject to challenge that. You have to be able to prove that that was excessive, for example. So a particular example, actually at the moment, we've seen it happen quite a few times. And with my role at Sharp UK, we do get these requests in. So there is a company out there at the moment that is selling a service that says to people, discover your digital footprint. And what it practically does off the back of that is do the right to be forgotten requests to businesses. So I've got an example, one I received at Sharp. And the way this actually works is an individual, let's just say it was me. I want to discover my digital footprint. This company, I must give them full access to my personal mailbox. So everything in my personal mailbox, they will have access to. Again, using their systems and tools, they will then go through that mailbox, picking out any references to other businesses or other businesses that individual might have had some interaction with over, well, the lifetime of that mailbox. And then they will then approach those businesses to asking them to delete my data, as the example here is shown. What is slightly ironic around this is the fact that obviously, yes, in the UK, we are protected by the UK GDPR, and all of us as businesses have strict rules and obligations around protecting that data. Again, the irony around this one is this particular company I'm referencing here is actually based in Israel. So these people that are going for this service are actively sharing their data with potentially very sensitive data, especially if we went through some of my mailbox, with a company based outside of the UK and EU. But actually, as a business, when you get these requests, regardless of where they've come from, in this instance, a third party on behalf of the data subject, you still have to legally respond. So there are companies now out there making money from this. So actually, one of the real drivers for the webinar today was to help you deal with these type of requests when they inevitably come in. From my perspective, one of the saving graces of the Sharp aspect to this is that Sharp, where we work, is a business-to-business model as opposed to business to end user. So no requests that we have had come in this format, and we're probably at 10 or 15 now, is actually related to Sharp. It's actually the commercial arm of Sharp. So I have to admit, it's been a bit of a lifesaver for us because these are incredibly complex and time invasive pieces of work. So again, having the great preparation in place does make it easier for you. So moving on, so I said we touched on this one, but every individual you collect data on or hold data on has the right to be informed that you have that data. And there are two articles that cover this off. Article 13 of the GDPR covers information that where you're collecting it from that data subject themselves. So typically, this looks like privacy notices on websites, your internal employee privacy notices as well. So this is where you are collecting directly from that person. There are, the ICO website is a fantastic source of information on this. They have lots of information around what should be in those notices, what's legally required to go in those privacy notices, what bits of text you should include. But actually, practically speaking, online, you can find some fantastic templates to get this done. For example, the other aspect of this is cookie pop-ups on websites. Again, it's all about informing people about what data you're collecting from them, be that explicitly by filling in forms or by using cookies, for example, you're collecting data about their habits and trends. So you have to make sure you are informing people around this, and specifically in relation to individual rights. You must tell those individuals when you're collecting their data how they can use those rights, what they need to do if they wanted to put in a subject access request. You have to inform them on it. And you also have to inform them the right that they can complain to the ICO should they not be happy. Article 14 is not as common, but an Article 14 privacy notice is where you have obtained data that hasn't directly come from that individual. So again, a lot of GDPR for a lot of people sort of killed off being able to buy data in for marketing purposes. There are exceptions to all of this, but again, if you buy in that data, acquire it legally, or legal mechanisms to doing it, then you must inform that individual that you have their data, and you do this through an Article 14 notice. So again, GDPR itself, the regulation itself has lots of information in this, but actually the ICO's website is fantastic at turning it into non-legal speak. Let's say that. So the first of the two we're going to look at is the right to access, a subject access request, and that's Article 15 under the GDPR. So it gives the individuals the right to access their data and receive a copy of it. But it's really about understanding that initial request. So I've put the legal text on there for reference, but again, it's obtained from the controller. The controller is the key word here. If, for example, Complete I.T share, we use Barclays Banking, for example, we will share our team members' addresses, maybe with Barclays Bank when they have a company credit card. If our team member wanted to invoke their individual right, they must come to Complete I.T. Barclays Bank is only a processor. They cannot respond and must not respond. And when these requests do come in, there is a time frame attributed to this. From the moment the request is received into the business, you must respond within 1 month. Again, slight caveats on this. There is flexibility built in for that when you respond, not from when you recognize it, when you respond. So if it falls on a weekend, for example, there is around a bit of flexibility around that. But again, planning to respond in a month and not rely on ifs, buts, and maybes is really important. That said, you can extend that timeline from 1 month by a further 2 months if the request is complex or if you receive a number of requests on that individual. Again, the definition of complex isn't actually in General Data Protection Regulation, but the ICO themselves have some advice and guidance around that. And as I touched on, you can refuse to provide the information if you have an exemption or restrictions applies. And again, or finally, if it's manifestly unfounded or excessive. Just be very careful with any of these exceptions, because you have to be able to stand by them and justify them to, if the data subject's complained, the ICO. So again, individuals can make these subject access requests in really any form. They can do it over the phone, they can do it in writing, they can even do it via social media. And actually, it doesn't have to be that person themselves. As we've seen with the right to be forgotten, applies here as well. Third parties can do that on behalf. And as I touched on, you can't charge in the vast majority of the cases to deal with these requests. When you're doing your searches, you should include any and all systems, and that includes things like WhatsApp in theory. People traditionally think, oh, emails and file server. No, any form of business communication is in scope, plus any third parties you have shared that data with. So any processor you may have, in theory, that is all in scope of that request. When you do respond, you should make sure that the information provided is accessible, and accessible. The individual who's receiving it will be able to understand it. And again, predominantly this is, request might be made over a phone, so you may agree that you want to respond in email, so in an intelligible format. And again, when you are disclosing it, you have to make sure you do this very securely. And what we'll go on to now is actually the practical steps for this, which is hopefully where everyone in this webinar will take some good points away. So the first thing you must do when you get these requests is verify who you're speaking to. Just because an email from a known email address has come in from that individual, so an ex-employee makes a request of you off that personal email address, the question you have to ask yourself is just an email request good enough? How can you verify that the person who sent that email isn't someone in that account fishing for some information? And that 1 month clock I talked about earlier on, during this verification phase, you can pause that clock. But it is up to you as the data controller is to decide what is good enough verification to justify the next steps. An example that we had here was we had a request come in and it came in via email. I then phoned that individual on a telephone number I had on record just to confirm that it was them who made that request. Again, worst case scenario would be we go through this process and share data with someone who is not the data subject. We start to go into breaches of GDPR. Next step is to understand that request. Do they just want to know what data you as a business process on, or do they want copies? Again, getting that difference could save you potentially a lot of work. The request could be, what data do you process on me? That could be a real top level table of everything. Or it could be, what data do you process on me? And I want to see copies of it. So really understanding that request at the earliest part is key. And if it's quite a specific request, or even a general request, you must notify everyone within the business that might have some involvement not to delete data. Businesses have got in trouble with the ICO where they look like they've tried to, well, cover some stuff up. And actually, if I know an email exists and it's not released to me as a part of the subject access request because someone internally wanted to cover themselves up and deleted it, that's quite a serious breach. And this is where you start talking fines because there is intent to not uphold the law. So make sure you notify anyone internally that might be affected by this not to delete anything. You'll get more trouble for deleting and hiding things than you would by just being open and transparent. What you can actually do is go back to that data subject and ask for clarification. It doesn't pause the clock or anything like that. But what it will do is twofold. It makes you seem like you really want to help this individual find the information that they're looking for. Again, that transparency piece. But secondly, it can also really help with your search. So again, asking for sort of terms you'd like, asking for references you'd like to that individual see, asking, are they looking for something in particular? Is it an aspect of their HR record, for example? It will make that search much quicker and hopefully easier. But again, from a data subject's perspective, you're wanting to help them. That goes down very well. You then will go on to undertake the search itself. And as I touched on, it's not just going to search emails, I'm going to search on the file structure or search SharePoint. You have to consider that scope of the request and does it include other systems? Does it include databases? Does it include third parties you share data with? This is where these can get very, very complicated very quickly, especially if the scope is relatively big. So let's just say you have collected all this data together. There's some fantastic tools in the Microsoft 365 to be able to help you with this, for example. You then need to start thinking about redaction. So you have to protect the rights of others. So the subject access request is about that individual's data. If other people's data is included in those search results, you have to start thinking about redacting it to protect them. Also, company data is not in scope of a subject access request. So for example, a business decision is not in scope, but communications related to that individual would be in scope. So again, these can be incredibly complicated, incredibly complex, especially if the subject is sensitive. And my recommendation would always be, if you are not sure protecting the rights of the others, protecting the rights of others, or that commercial aspect to it. Seek advice, because what you don't want to do is overshare and put others at risk, or overshare and put your business at risk. And finally, once you have all this, all the information you believe meets the scope, and everything is redacted and secure, you can send it to that data subject. Agree with them how you're going to share it with them, and share it securely. So again, you're sending lots of data en masse, potentially via email, which is a common way that data is shared. Make sure the email is encrypted. Send passwords separately. These are the basic pieces around that security element, but you have to make sure the one overarching practical step that covers all of these points is document that journey. Document that you've understood, you've documented in there that you believe, for example, that the data subject is who they say they are, and for these reasons. Document each step. Take evidence that you're notifying stakeholders. When you're doing the search, document, I searched this system, I searched this SQL database, I searched this. And when you have responded, again, just document that when you've done it. So put your time frames and all this. Practically speaking, if the ICO ever come to then ask you, because a complaint has been made, you can pull out your documentation. These are everything I did to be as open and transparent with that data subject as possible. And any decisions I made along the way are here for you to see. So that's the practical steps in doing individual rights requests related to subject access requests. The steps that we'll move on to now about right to be forgotten are very similar, but there is some subtle differences here. So right to erasure, right to be forgotten is Article 17. So again, we see the words controller. If I had a data subject, if Complete I.T is the data controller, if it was Barclays Bank, I couldn't write to Barclays Bank and say, please delete my data based on what was shared with you by Complete I.T. It has to go to the controller. There is a real difference between right to be forgotten, though, and subject access request. And the fact that this right is not an absolute. Subject access request is share my personal data. You have to share your personal data. Right to be forgotten doesn't work the same. So there are 5 criteria here that the request is only valid if it meets one of these. So if you collect some data for a purpose, and that purpose is no longer valid, the request is a valid one. If data has been collected on the concept of consent, and then they remove their consent, and there's no other, say, legal obligations to hold this, you have to remove that data, or the right to be forgotten request is valid. Again, touching on some of the other individual rights, the data subject has a right to object. Again, there's no legal grounds. The request is valid. If you as a business have no legal basis at all, and there are 6 legal bases for processing data, then they have that right. And finally, if, for example, through a formal legal channel, the data request is made, that can also be real. But again, there are 2 reasons when it does not apply. So we all have team members, and we have a legal obligation to retain HR-related data for 6 years. That legal requirement takes precedent over an individual's right to be forgotten. But again, think about the scope of it. And we as businesses have the requirement to keep certain data for 6 years, but not other data under that obligation. So in those instances, you would be right to delete their data. And again, finally, if the data was to be used as a part of a legal defense, the fact that you have a legal defense means that is a good enough reason not to accept the request. Once the legal piece has been through, then the request becomes valid again. So apologies, it's a very wordy piece, and we can share these slides afterwards, but it's because we are talking in legal text and legal terms now, which is always a challenge. So again, practical steps, as you may see, very similar to the last section. So again, you're going to be verifying it, it's at individual, using second methods to talk to them. So if you get the request by email, go back to them by telephone, for example, again, make sure you document it. The understanding of the request again needs to happen, and then the search be undertaken. But this is where it differs. You understand the data and your legal requirements to therefore say, is this request valid or not? And it is at that point, and only that point, once you've done that assessment of what we've got and is this a valid claim or not based on, for example, HR laws, you can then delete the data. And you have to go back to that individual within that 1 month, the 1 month applies, to let them know it's been done. So again, as with the previous one, document from the top to the bottom what you're doing, where you're making those assessments. So understanding the data. This data is in scope of health and safety laws, apologies, human resources based laws. Therefore, I must keep this data for this time. But this other part of the request is valid, and therefore I will delete the data, record all of this. And where these requests are being made by third parties, like the example I gave earlier on, you just have to respond once you have done all this work, stating what has been done. Again, just because it's come from a third party, it doesn't mean the request is invalid. So outside of these practical steps, there's some other best practices that you should be doing as a business to help when you get these requests. So first of all, practice data minimization. It's one of the core principles of the GDPR, and it is about not holding data that you don't actually need. So for example, typically if we think about the world of marketing, if you haven't, or a prospect of yours, you have their data, you have consent to have it. If you've not interacted with them, or they've not interacted with you for example, a year, this is all your own judgment to make, just using an example of 1 year. The question is, should you really keep that data? Because actually, if you are compromised, then you'd have to deal with this as an incident. And again, those requests can be made for you. If you can go back to the individual and say, yes, appreciate, we probably had your data 2 years ago, but we have a 1 year retention policy, at which point we delete your data, you can be confident that you really shouldn't have their data, and the workload for you would be minimum. One of the next pieces is to have a record of data processing. This is actually a legal requirement under Article 30 of the General Data Protection Regulation. And it really is a record of what data you have and everything around that data. So what data subjects you have data on. So that could be employees, that could be prospects, that could be customers, the other data subjects. What you have, so it could be their names, addresses, emails, why you are processing it. So for example, we have our team members, and we're going back a bit now, but we used to have team members' addresses stored in our systems so we could send them their checks in the post. Okay, I appreciate most businesses don't do that anymore, but again, it's a reason for processing data. And that's it, you document that legal reason, and there are 6 of them. And finally, the best piece of best practice is including in that record who you've shared it with, what other parties you have shared that data with. Again, legal mechanisms for sharing, but you must make sure that, so when you do get, for example, subject access request, you know, I have this individual's data, this is the type of data we hold on them, the legal reason we had it in the first place was this, and we have shared it with these other businesses for this purpose. It makes your searches much easier. As I touched on with data minimization, one of the other principles under the GDPR was not to retain data forever and ever. Storage limitation is what it's described as. So have a data retention policy that is a very transparent piece of work that you then live up to, that says we keep this data for this long. After this amount of time, it's deleted, for example. And then make sure you live that. Numbers of systems have these tools built into them. Number of systems don't, and you have to go manually do it. But it's really important to keep on top of it. Next, an information asset register. So this is a much more detailed piece around within your 4 walls, digital and physical, where you store your data, and actually include in this what security you have in place, because then you can start to understand if you are challenged on it, you can start to say this is how we secure it, and understanding those, what tools they are in there to help you deal with these requests. An example of this was in the Microsoft 365 environment. You've got the e-discovery tools. So if you do have a subject access request, you can use these tools to help you find that data within that Microsoft ecosystem. So an information asset register is really important because it says that, the record of data processing says what you have. Information asset register says how's it stored, where's it stored, how's it stored, and how can you help me look for it? And finally, so having those supplier agreements. So where you have a data process, and I'd like to hope many of us in our offices, for example, have confidential waste bins that companies come around and empty for us. Having a strong agreement with that third party that says you must dispose of these bins in a certain way is really important. But actually, also make sure you include in those supplier agreements where they need to help you dealing with requests, such as subject access request. So again, our agreement with, for example, top example, our bank is that if we get a request that comes into Complete IT, they are under some form of contractual obligation to review any data we've shared with them and act on our instructions around what we do it. And Complete IT and all of this, we can help. We have templates that we can share around those record of data processing, retention schedules, information asset registers. And again, in the actual search piece, we have got experience with the tools, such as the e-discovery tool within Microsoft, to help you do those searches. What we can't do is help you make decisions based on the data, because that's your data. But what we can help is present you with the data, present you with ways of documenting these searches, ways of documenting all those processes we touched on earlier on, and guidance around how you do all this. So again, we can help with those. So that brings to the end of the webinar today. Massive thank you for everyone who attended. Again, as I touched on earlier on, this isn't the most exciting subject in the world, but it's actually very important for us all to make sure that in the event of these requests do come in, that we can all respond well, and we can all respond in those timeframes, so we don't get in trouble and we don't have eyes prying on us that we don't need to. Since the GDPR when it was introduced, everyone was scared of massive fines. There has been very limited numbers in the big fines. It's the ICO in particular has very much been ramping up in the last probably 12 months, small and often. So again, we're not talking huge numbers, but these are still important things for businesses. And when these things do creep into the news, they probably do more damage. So quick, I've had a couple of questions. Let me have a look. Do we get a copy of this and the recording afterwards? Very happy to share the slides with everyone who'd like them. Jodie, who's very kindly organised this for us today, I will share her the deck so she can send it out. And I've recorded this to the cloud, so I can ask Jodie to kindly share that one on. Another question is, what has changed in the last few months? For me, the big change has been around that commercial businesses turning these sort of requests into money. It's very, I have to say, it's very clever. The marketing aspect of reducing my digital footprint is very appealing, and it sounds very appealing. But actually, when you start to dig under the business doing this, you start seeing it actually goes against what the individual probably wanted in the first place. So that, for me, has been the real big change in this. I've seen subject access requests frequently over the last few years across the Complete IT, Sharp, and our clients, but the real change has been in this right to be forgotten. And again, it's a bit simpler than the subject access request, but you still have to legally respond as you normally would. Let me just then see if there's any others. No. Okay, I have no more questions, but feel free to reach out to Jodie and I if you have any more questions, and we'll say we will share the slides and hopefully share the recording very shortly after this one. So thank you very much all for attending, and have a great rest of your day.